Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
They got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
This is the next search on February 28, 2020. 7:44 p.m. How does the FBI find people? The people's misspelled P-E-O-O-P-L-E.
I object.
Did the defendant find out how the FBI finds people in this case? Oh, she found out.
What more do we see?
Good afternoon. Welcome to the Court of Public Opinion. I am the Recovery Addict. Good to have you here. Welcome, welcome. Come on in, take a seat if you have one. We're going to return to court shortly.
I was told counsel wanted to see me at sidebar.
No, that's not a sound clip. Counsel wants to see you at sidebar right this very moment. We're back, but it's okay. A sidebar is happening.
Thank you, sir. You're my good friend.
We'll just keep looking at the fan and pretend nothing happened. I don't like podiums. All right. Here we go. There we go. Siren counter.
Back, taking it easy.
Siren counter at 113.
Happy birthday. You look good.
Judge Fleischer, how you doing? Thanks for popping in.
Somebody just sent me a video of roaches fighting. I don't know who won.
Don't know who won. All right. Sidebar is occurring as we speak. So we will wait just a minute. People are filing in. Couple empty slots up there in the media row, where a couple Macs are representing well.
About to catch a whooping.
Someone is. A few family member slots are available as well. Sounded like you added that in. It just came in perfectly. It just started. Who's doing cross? I think it's Alessi. I think it's Mr. Alessi. Open up a new tab and let's go, says Shirley Knotts. Just don't close it, whatever you do. Okay, I think if it's Mr. Alessi, I think they need to question her on is the record made when the tab is opened or closed? Because I think we've got conflicting information between this witness who's on the stand, who's doing a good job, and Mr. Whiffen, who also did a good job. But they need to agree on when the timestamp is entered, and I think they've disagreed. One says when it's opened, one says when it's closed. Maybe I heard wrong. Please make it sidebar. Let me go grab the audio really quickly. Fast forward. There it is. Yes, let's try this. Is this the right audio? Not that part. Just right here.
I was told counsel wanted to see me at sidebar.
There it is.
I was told. I was told counsel wanted to see me at sidebar.
Got it.
You are unmuted.
All right, jurors. As you know, I think I told you in the beginning, one of my functions is to make sure that a case is tried fairly and efficiently, and not to waste anybody's time. So if I get frustrated at lawyers about something, I try not to, and I don't think I am, but if I seem to cut somebody short, the lawyers are just doing their job. When they request sidebar conferences, they're just doing their job. I am going to try and keep all sidebar conferences to a minimum, but the lawyers are just doing their job. Okay. All right, go ahead, Mr. Alessi. Let's go to the witness.
Was that an apology?
I just need a witness.
Yeah. Was that an apology? Wendy, Fire Girl, handmade by Wendy. First in chat today. The internet is yours. Keep it running for the rest of us. It's going to be great. You've won before. You've won again. You're a repeat offender. This goes on your permanent record. Thanks for being first in chat today, Wendy.
Certainly.
Backhanded apology.
Good afternoon.
Afternoon, Your Honor.
May I, Your Honor?
Yes.
Good afternoon, Ms. Hyde.
Good afternoon.
I notice you have some documents with you. Could you just state what is in front of you so I know that I might be able to help expedite this if I know what you have in front of you?
Absolutely. I have the first digital forensic analysis report I completed for the previous trial.
Do you have a date? You have several of them.
I do. It's the first one. I apologize. This is the one, I believe it's May. I don't remember the
May
date
of
off the top of my head.
2023,
May
perhaps?
of 2023, obviously.
Yep.
Then I have the second one. This was the one that was used in the pretrial motion.
December 2024?
December 20. Yes, that's correct. Very nice. Then I have the third one. This is the final one regarding the phone that was identified as Ms. McCabe's.
Yes.
And then I have the fourth one, which is the phone of Mr. O'Keefe. And then I do have the opinion from State versus Huera, but if we don't need that, that's fine.
Okay, very well. I appreciate you telling me that. In March, and you recall on your direct examination, Attorney Brennan asked you questions going to your experience and qualifications. Do you recall those questions?
Yes, I do.
You were involved in a case, is actually a murder trial in the state of Maryland in a case called State v. Herrera as recently as March of 2025, correct?
Correction, it's an attempted murder.
Attempted murder. And in that particular case, you had attempted to offer various opinions to the court, correct?
I object.
You have to move along from this case, from what you're talking about. You have to move along from that Maryland case.
So with regard, do you recall another case from the state of Massachusetts, Arrington case, in which you submitted a pro se amicus? Do you recall that case?
I do.
And is it correct that in that case you submitted arguments on behalf of the prosecution in that case?
I submitted an amicus brief, which is not on behalf of anybody. It's as a friend of the court.
Right, but the friends of the court, you took a position in that, quote, friends of the court brief, correct?
Took a position on the evidence.
Right, and the position you took on the evidence was that the frequent location history data is reliable and should be used. Is that correct?
The statement is that frequent. I do not have that amicus in front of me. It has been a year and a half since I've read it. But that amicus does discuss frequent location history records, and I want to be clear, it speaks to both bias on both sides and negative and positive of submitting it. It was an unbiased writing, and it was not specifically in support of the prosecution.
So you are testifying in this case on behalf of the prosecution, correct?
In this case, I was hired by the prosecution.
Right.
That's correct.
And the prosecution is paying you for your services in this case, is that correct?
Yes.
And with regard to this case, you have been paid and have been on this case since May of 2023, correct?
That is correct.
With regard to the various reports that you have submitted in this case, you have mentioned one which is a report with regard to the iPhone of John O'Keefe. Is that correct?
That is correct.
And you have, in that report, you have made a statement, have you not, that from 12:20:50 a.m. on January 29th of 2022 and after, there is no indication of interaction with the device. Is that correct?
There is no indication of user interaction with the device. There is all received until about 6:04 a.m. when there is again Apple Health data that picks up.
I'll ask it again. And you can feel free to turn to page 1529 in that report.
Page 15?
Page 15, 1529.
The report is.
Would you like the page
pages.
of the report or the page NDA number at the bottom? I can do either way.
I'm sorry. I thought you were saying page 15 in the report.
No. It's NDAO 1529
yes.
or page 7, whatever way.
Page 7. Okay, Roger.
Okay, so page 7, you see there's a heading Interactive Phone Activity, correct?
Yes.
And at the top it says, using a variety of different artifacts, we can see active interaction with the mobile device up until 12:20.
Yeah, you have to slow down.
Okay, sorry about that. I'm just trying to move it along, but I will be slower. I'll repeat. Using a variety of different artifacts, we can see active interaction with the mobile device up until 12:20:50 a.m. ET. You see that statement?
Yes.
And that if you skip down, I'm going to skip a couple sentences to the paragraph under the chart, and this is the key part.
Okay.
It says, from that point, and I'm understanding that point to be the 12:20:50 a.m., correct? Mm-hmm. You need to say yes or no, I'm sorry.
Yes.
There is no indication of interaction with the device. Did I read that correctly?
That is correct.
So I am going to... and you believe that statement is correct?
Until 6 something a.m.?
No, I'm sorry. I'm just asking if that statement is correct. Not if you have other information, but is that statement correct?
I object.
Can you answer that? Can you answer that, yes or no?
Did I read that correctly?
You read it correctly,
Thank
yes.
you. If we could, Your Honor, have a document that is put up already in evidence and publish Exhibit 39. And it will be, thank you. And if we could go to slide 82, please.
Curtains, Jim, curtains.
And Ms. Hyde, if I could draw your attention to the entry that is, it says 3209 under app lock, but we know that the 00 is a 12. So it's 12:32:09 a.m. on January 29, 2022. And I'm going to read what it says in red, and this is a timeline of Mr. Whiffen. You know Mr. Whiffen?
I do know Mr. Whiffen.
And so he put in red, not us, he said device locked with lock button for the last time. Do you see that?
I do.
And you know that to lock a phone, you actually have to hit the side button with regard to an iPhone to make it lock. Do you know that?
Yes, sir.
Okay. And that is an interaction with a phone, is it not?
I concur.
So that means that that interaction with the phone occurred at 12:32:09, correct?
I did not review that specific artifact. I cannot attest to Mr. Whiffen's exam, only to my own.
So do you have any reason to believe that what is in evidence in this case that Mr. Whiffen has produced, and that do you have any basis to contest the fact that the device was locked with a lock button for the last time on the phone of John O'Keefe at 12:32:09 as you sit here?
I cannot contest it because I do not recall looking at that specific artifact.
Don't you think it would have been appropriate to be accurate as a digital forensic analyzer on the topic of the last of an indication of interaction with the device? Don't you think it would have been appropriate to look at that 12:32:09 in any of the tools you said you used on direct?
I did not correlate that artifact in my timeline.
I understand you didn't, and my question is, you make a statement. Well, let me back up. Do you understand that in this case, as in many cases, that matters of seconds in activity can be determinative of a case. Do you understand that from your experience?
Absolutely.
So it's important, therefore, to get activity right for any data forensic examiner when they're issuing reports about activity, particularly of a decedent. Is that important?
Absolutely.
So isn't it correct that the statement that you make on page 7 of your report, that from that point, 12/20/50, there is no indication of interaction with the device, is incorrect?
I cannot make that without going back and reviewing and validating the artifact you just produced from Mr. Whiffen. I would need to validate that in order to respond to that.
But as you sit here, you have no basis to contest what Mr. Whiffen has stated, that there was a lock button on the side of the phone of Mr. O'Keefe a full 12 minutes after you say there was no interaction with the device. Is that correct?
I don't. I would have to review that portion.
Is there anything that had prevented you from reviewing that in that data before you wrote this report?
Not that I can think of. I would have to go and re-review that.
My question is...
I don't know if that artifact, I have not reviewed that artifact, so I cannot speak to an artifact I have not reviewed, and I did not, that is not my report, that's Mr. Whiffen's report, so I cannot speak to that without going back and reviewing that evidence.
Isn't the interaction with the device, a lock button, readily available to you in the data that you have and had in your possession when you wrote this report?
Yes.
Thank you.
There was the push. Put her on edge.
If you could please turn to, in the same report, page 1528, which is your page number 6. And I just want you, please, to go to the, just put a placeholder in that. And if you can now just go to the conclusion, which is your page 50. Let me know when you're there.
I'm there.
So in the conclusion, you state that starting at 12:01 a.m. on January 29, 2022, the mobile phone was in use with activity of Waze navigating to 34 Fairview Drive, Canton, MA, active interaction with the screen, steps, audio playing text messages and calls until 12:31 a.m. EST on January 29, 2002. Did I read that correctly?
Yes.
That statement is also incorrect, isn't it?
On what basis?
Do you believe that statement is correct or incorrect?
I believe that the statement is correct regarding those artifacts that are mentioned in that statement, yes.
Okay, if you could please, if you could turn to page 1535 of the same report.
Can you give me my page number, please?
I will. I'm
okay,
just,
thank you.
You're welcome. If you could turn to your page 13.
13, Roger. Yes, I'm there.
And do you see an entry that says 12:31:56, which is the same time in the conclusion, but I'm going to develop it.
I believe I know where you're going.
Well, hold on. I'm sorry. I need to ask the questions. Yes. I appreciate you looking to help, but if I could, I'd appreciate it.
Absolutely.
Thank you. So it's got health steps, and it has steps 36, duration 20.9 or 20.398 seconds. Did I read that correctly?
That is absolutely correct.
So if you look at this data point in your report on page 13, the steps began at 12:31:56 but they ended 20.39 seconds later at 12:32:16. Is that correct?
That is correct.
So therefore, your statement in your conclusion, if you could go back to 50, and this is in your conclusion, your statement there is that the steps, the mobile phone is used with activity, including steps, until 12:31 a.m. EST. That should read until 12:32:16, correct?
It depends on your interpretation of interaction. As a user is walking, they're not actively interacting with their device. It's their movement that is. It's not direct interaction with the screen. But I would agree to your view that that could be interpreted as needing an additional 20 seconds.
Isn't the more correct way to state the conclusion that the active interaction when it comes to steps is not calibrating using the screen, but the phone is calculating steps taken? Isn't that correct?
That is correct, but that's not interactivity with the device.
I understand,
yes.
But the sentence reads includes steps, and the more accurate way to have stated that would have been to put 12:32:16 instead of 12:31 a.m., correct?
I'm sorry, you just said 12:30. I did this to the minute, not to the second. Could you rephrase what you were stating?
Well, I'll state it again.
I appreciate that.
You're welcome. So isn't the more correct way to state this important data point in your conclusion, instead of saying active interaction with the screen and steps, etc., until 12:31 a.m. EST, the 12:31 should be 12:32, because the steps that you have on your page 13, by what you concede, is the duration of 20 would have brought it to 12:32:16, correct?
I would state that depends. I believe either is a correct way to state that. Based on interactivity, based on your interpretation, your definition is more correct.
Okay, thank you. And it's not my interpretation. I'm reading from your report, correct?
Your interpretation, representation of interaction is based on your theory that interaction concludes when the steps end. And I'm saying both would be acceptable.
Okay, so let's follow up on this.
Sure.
Sure.
Isn't it correct that it isn't my theory when the steps ended?
Oh, it's not.
If I could just finish,
Please, absolutely.
Because if we talk over each other, the stenographer's not going to get both of us. Thank you. So it's not my theory. It's just the simple math from an entry you've made on page 13 that the steps began at 12:31:56. They ended 20.398 seconds after that, which, just doing the simple math, is 12:32:16. Did I do the math correctly?
That is correct.
Okay,
I'm not debating that.
Thank you very much. So now what I'd like to do is to go to page 1528 of your report.
Do you have my page number for that? I'm sorry.
Yes, and I appreciate that you go page number, so I center in on the lower one, then I'll go immediately to the one. So it's your page 6, Ms. Hyde.
Thank you.
You're welcome. Just let me know when you're there.
I'm there.
If you could please go to Apple Health Data Steps.
Mm-hmm.
And we've been talking about steps because they're important enough that you put them in a report, correct?
That is correct.
So let's go to an important data point, therefore, in your report, in the chart, which is the second entry, which is, as you've stated, 12:21:10 a.m. Do you see that?
I do.
And you note under the data that John O'Keefe's phone registered 80 steps at 12:21:10. Did I read that correctly?
You did read that correctly.
And those 80 steps constituted 191.253 seconds, as you state, correct?
That is what is stored in that database, correct?
And is my math correct so that the jury understands this perhaps a little better,
sure,
that 191.253 seconds equals 3.2 minutes.
Approximately, yes.
Approximately.
I'm doing the math in my head, so that's why I said approximately.
Right. Understood. So am I reading this entry correct, that you're stating what the data shows, that 80 steps were taken by the phone, whomever had the phone of Mr. O'Keefe? There were 80 steps taken at 12:21:10 a.m. on January 29, 2022, for a length of time of 3.2 minutes.
That is what the phone registered.
That's what the phone registered. Very well. Now what I'd like to do is to turn to the phone of Jennifer McCabe.
Okay.
And that is, for your reports, you don't date your reports, so I can't give you a date, but it says...
It's report 3, I believe, is what you're looking at.
Exactly. It's 3. And there is... Bear with me, I'm accommodating your page, and I'll have it soon for you. It is your page 7. And let me know when you are there.
I am there.
Are you aware of an issue regarding the time of an interactive phone activity on Jennifer McCabe's phone at 5:07 a.m.? Are you aware of that issue, and particularly a communication to a person named Coco? Are you aware of that?
I would need to check in my report. May I turn to the page
Absolutely.
for that time?
And
I do see an outgoing call to someone labeled Coco at 5:07:21 a.m.
And you can tell that because in your report on page 11, you list a 5:07:21 a.m. call to a Coco as outgoing, correct?
Correct.
Have you discussed that call with any member of the Commonwealth?
No.
And again, this call is at 5:07 a.m. on January 29th of 2022, correct?
That is correct.
There is no duration listed for that call. And if you just follow my questions, if you can, yes or no. Is that correct? There's no duration yet listed.
Correct.
So what I want to do is to also note that that omission is not the only omission of durations from this report, or I'll state it differently, let me withdraw that. There is no population of the duration column for any call from 12:14:30 a.m. on January 29, 2022, all the way through this 5:07:21 call, and you don't start listing durations until 8:59:34 a.m. Is that correct?
Yes, and explainable. The artifact.
I understand,
yes.
Mr.
Okay.
Brennan can
Sure.
handle those on his redirect.
Absolutely.
So there's not a population of duration of calls after numerous early calls and phone, as you call it, interactive phone activity. Nothing populated in this report until 8:59:34. That's correct?
Yes.
All right.
The sound's no problem on my end. I have to refresh your page if you have bad sound.
Now what I'd like to do is to turn to the 22740 artifact that was the subject of much discussion on direct. And I am going to refer to that as an artifact. Is that a parlance that is familiar to you?
Yes.
And if I refer to that as a timestamp also, is that a parlance that's familiar to you?
Absolutely.
So I can refer to 2/27/40 as a timestamp, and you would find that parlance acceptable?
Yes.
Thank you. So I'm going to do that. Just to keep it simple, I'm going to refer to it as a timestamp. Now, you've been on this case working for the Commonwealth since May of 2023, correct?
May 4th, 2023. That is correct.
So you've been on this case for 2 years.
May the 4th
correct?
be with you.
Not actively the entire time.
But you started on this case in May 2023. You issued a report in
Correct.
May of 2023, correct?
Correct.
You issued a report in December of 2024, correct?
Correct, after being rehired in November.
Right. And you issued more reports in 2025, correct?
That is correct.
So all of that activity has been on this case, correct?
All on this case. That
and
is
that's
correct.
been all on behalf of the prosecution, correct?
That is correct.
None of that work has been done on behalf of the defense, correct?
That is correct.
So let us now go to the timestamp of 2/27/40. Your opinions on what is the meaning of that timestamp have varied from May of 2023 until today. Is that correct?
No, that is incorrect.
Let's cover that issue.
Sure.
Let's turn to your May 2023 report. Isn't it correct that the report and your findings were pursuant to a request from Detective Lieutenant Brian Tully?
Correct.
And how many interactions have you had with Lieutenant Detective Brian Tully on this case approximately?
I really don't know. I'd have to go look back at email and call logs.
Is it more than 5?
Yes.
Is it more than 10?
Yes.
Is it more than 20?
I don't know.
So somewhere between 10 and 20, would that be fair?
Again, I'd have to review my call logs. I'm not going to test.
But it was more than 10?
More than 10, I'm sure.
So the issue was your use of various forensic tools that revealed a timestamp, 2/27/40 a.m. timestamp on January 29, 2022. Is that correct? Is that a fair characterization of an issue you looked at?
Correct.
So if you could go to page 5 of that report. And I would ask that you go to the last paragraph that starts with "in the instance of the Google search," and let me know when you're there.
I'm there.
So it reads, "In the instance of the Google search, house long to die in cold, that was recovered from the write-ahead log associated with the X-Browser State DB SQLite database with the timestamp of 2/27/40 a.m. was marked by Celebrite as having this timestamp and being deleted." Did I read that correctly?
Fair. Yes.
So you use the words that Google search, "house long to die in cold," was associated with the timestamp of 2/27/40 a.m. Isn't that what your words are in this report?
In that database, they are associated. That is correct.
Right. And in terms of page 3, if you could go back, of your report, under relevant findings. It starts with, "There were 2 searches of interest that took place on the iOS device," and we're talking about Jennifer McCabe's device, correct?
The device that was identified to me as Jennifer McCabe's. Yes.
That's identified to you as Jennifer McCabe. And it's what you talked about on direct examination as her device, right?
Yes.
It's not a mystery as to whose it is. It's not like you don't know, right?
In direct, I also use the phrase "identified to me as Jennifer McCabe's."
Right, but your conclusion is the device you've been working on and analyzing for 2 years is the device of Jennifer McCabe.
That is how it was identified to me.
Do you have a different conclusion as to whose device it is?
I always am very, very careful that I did not assess the ownership. That was information that was given to me, not information that I personally assessed.
So are you uncertain as to whether the device you've been working on for 2 years is the phone of Jennifer McCabe?
The device that I have been working on for 2 years is the device that was identified to me by the Massachusetts State Police, Detective Tolley, as belonging to Jennifer McCabe when I began working and received that device, as stated in the evidence analyzed section on this same page.
So let's go, and we're talking about, again, to get back to the center of gravity, we're talking about a timestamp of 2:27:40 a.m., correct?
That is correct.
And when you issued your first report in May of 2023, the timestamp you were looking at was 2:27:40 a.m. January 29, correct?
I was looking at multiple timestamps associated with the same 2 searches.
Right. So what I'd like to do, you said multiple timestamps. What times are in the multiple category?
What I was tasked to do was to look at the times, the search, the Google search history, I'm sorry, not Google search history, the Safari history, which includes Google searches, associated with those 2 search terms within that 12-hour period. That was the particular task, not the task of looking at the 227, just for clarity.
Right, and I appreciate that, but my question wasn't that. My question was, I thought I heard you on direct examination, which is why I repeated the question, what I thought I heard on direct, but I'll ask you the question.
Sure.
You looked at and talked about on direct 2 potential times for a Safari search, which includes Google, one of which was 2:27:40 and the other one was 6:23 a.m. Is that correct?
I analyzed the meaning of those 2 timestamps.
Right, so we're just talking about 2 times, 2:27:40 and then 6:23. Is that correct?
So you are only talking then about the one that we're also talking about 6:24 a.m.
Okay, so we
Eastern time for clarity, because some of these records are in UTC, some are in local.
Fair enough. So you've got 2:27:40, you've got 6:23, and you got 6:24 that you were looking at, correct?
There are other timestamps that exist in the realm of what I was looking at, but those ones, correct, are the ones that are relevant in this report.
Exactly, and that's what we're talking about.
Okay,
we're just talking about this report.
Yes.
And so if you look under relevant findings, at the very bottom paragraph, you say, second sentence, a Google search for how long to die cold at approximately 11:23 a.m. and then how long TIDIE in cold took place at 11:24.
That is in UTC. I apologize for not having the time stamp format there, but that is the UTC time. The UTC time equivalent in Eastern Local Time would be 6:23 and 6:24.
So to be clear, in your report, you wrote 11:23 a.m. and 11:24, and you didn't put UTC next
correct.
to it, did
They
you?
should. You are correct. That should say UTC. That is a typo.
And there's a significant difference between 11:23 and 2:27:40, correct?
11:23 is UTC, so its equivalent in Eastern Time would be 6:23. The artifact of 2:27 is already in local time, so that is in Eastern Time. So what we would be comparing is 2:27 and 6:23 and 6:24 to be appropriate. They're taking into account the data storage and which ones are in UTC and which ones are in local time.
I understand your explanation now.
Perfect.
But in this report, there is no UTC time down. You have 2 additional times in addition to the 2 times, 2 different numbers added to the 2, correct?
On your end.
The UTC was a typo. It should say UTC next to those, and the chart shows all of those artifacts in EST and is clearly labeled that they're all in EST.
So you would agree that it's better stated to state it a different way than you have in your report?
I would say that both are equivalent. I should have had UTC there. But yes, it's easier for the audience to speak in EST. I would say forensics examiners typically communicate in UTC, but we translate for our reports. And I should have either communicated that in EST or included UTC. I will definitely contend that.
So,
in
terms of
concede.
Your
Michael, thank you very much for the super
May
chat.
2023 3 report, your first report in this matter.
Yes.
You, on page 5, in the sentence underneath the block paragraph, state, in the instance of the Google search, House Long to Die in Cold that was recovered from the write-ahead log associated with.
That's correct.
The X browser stage with a timestamp of 2027:40 a.m. was marked by Celebrite as having this timestamp and being deleted. Did I read that correctly?
You read that correctly.
Now let's move ahead to page 7 of your report. Up at the top above conclusion. Importantly, at this time, you state, testing shows great inconsistency with timestamps parsed from this file. It is, however, definitive that the page existed in a tab.
Correct.
While a definitive reason as to why the timestamp is listing the time of 2:27:40 is unknown, the time is inconsistent with the timestamps associated with the same search. Did I read that correctly?
You did read it correctly.
So as of May 2023, you said the definitive reason as to why the timestamp is listed as 2:27:40 is unknown, correct? I'm just asking, is that what you wrote? Unknown.
I believe that the wording here is, sorry, I know I do use the word unknown. It says, while a definitive reason as to why the timestamp listing is the time of 02/27:40 is unknown. Sorry.
So you use the word unknown, your word in your report.
Yes.
Okay, so now what I'd like to do is to go on to the first proceeding in this matter. Do you remember giving testimony in a proceeding about a year ago under oath?
Yes, I do.
Yes, I do.
I am now going to go to that testimony, and
the jurors feel yelled
if
at.
at any point you would like to have a copy of that, if it's the honor, if Your Honor would like, I will do it, but I'm going to start and then we'll see how it goes. So, bear with me a moment.
I wonder if he'd be able to ask if you ever attempted to testify in
Do you
trial
recall
and been excluded.
in that testimony stating that you processed the image in several forensic tools? I used Celebrite Physical Analyzer, and then you list many other tools. Do you remember giving that testimony?
We have a page.
I'm sorry, Mr. Brennan. I thought I'd given it 1-12. My apologies if I didn't. It's June 14, 2024, page 1-12.
Thank you.
You're welcome. So, do you recall giving testimony about the various tools you used for this timestamp?
I do.
And do you recall stating that those tools were commonly used digital forensic tools that are very standard? Do you recall that?
I'd have to see the wording that I used at that exact time.
Would it be helpful to refresh your recollection if I showed you that?
It would be great. I would greatly appreciate that because I do not recall the precise wording, but I know that I spoke to the tools I used.
May I approach, Your Honor?
Judge wants her to have a
Yes,
copy.
Mr. Alessi, you offered a transcript. Do you have the whole
I
transcript?
have the whole transcript if that helps.
It might speed things along.
Agreed.
Okay.
We have one. I'll provide it. Ms. Hyde, I'm going to give you a transcript.
Thank you. I appreciate it.
Just a Girl Baking sent 5 memberships. Thank you very much, Just a Girl Baking. Appreciate your support. Welcome, new members.
So, may I approach, Your Honor?
Yes.
Thank you. Mr. Brennan.
They're so polite. They must be friends outside of court.
Let me turn it over to 112. You are. Let me turn it over to. It's going to be 112.
Sorry, I'm going to stop pushing buttons.
Yeah. You're welcome.
Thank you so much. And you said we're on 112?
Yes, please.
113, I see it. I see it's highlighted on the copy, so I
Right,
figured
so
that's the
what I
one.
wanted to do, the reason I said 112 is that's where I started with my previous question. So I'm not going to repeat the question, but just to orient you, so you have a fair context for the questioning.
Fair.
So I started at the bottom, 112, now I'm moving to 113, and I'm starting with line 7. Do you see that?
I do.
And it says, yes, they are commonly used digital forensic tools that are very standard for other forensic examiners to use on mobile exploitation. Did I read that correctly?
That is correct.
And then if you go down to line 22, you testified in that proceeding, so it's important to use multiple tools so you can see the results from different data sets, and be able to compare those results and enhance those with manual analysis. Did I read that correctly?
You did, that's correct.
And then going up to page 114, line 5.
Slow down a little bit, Mr. Oleski.
I will, Your Honor, thank you. Yeah, that's very, very typical for me to process with multiple tools to ensure that I'm getting the most complete interpretation from forensic tools. Of course, you go beyond that with your analysis, but it's absolutely pertinent to that. Did I read that correctly?
That is correct.
And then lastly, for this section at page 114, 17, the Sanderson tool is meant to look at specific type of data structures called the SQLite database. XQLite databases are very nuanced, and this particular tool allows you to take that database and explore it at a deeper level than the other forensic tools allow. Did I read that correctly?
Yes, you did.
Thank you. Now if we can go to page 124 of the very same testimony. And feel free to go back a page just so you can see to page 123 that the topic is the 2/27/40 timestamp associated with house long to die in cold.
Can I have a moment just to review and get context?
Absolutely.
Thank you so much.
Page 123, 13, but if you need to go back further, feel free.
If you'd like to come over for dinner tonight, that would be great as well. We're having pot roast. Bring rolls.
Okay, I'm good. Thank you.
You're welcome. So what I want to do is start with page 1-23, and this is your testimony. On line 16. I have them in the timestamp order that is associated with the artifact. You use that word associated again, correct? Did I read that correctly?
Yes.
And that's associated with the Google search "House Long to Die in Cold" in a 2:27:40 a.m. timestamp, correct?
That is correct.
Now if you turn the page of the testimony, you state back then that on page 124, line 1, the browser state DB is an artifact that speaks to when tabs are moved. So when you're using your browser and you open different tabs, you may have a search that this time pertains to the time that the tab moved. It could be lots of things. Did I read that correctly?
You did.
Good boy.
Not one thing. You said it could be lots of things, correct?
That is correct.
And then you go on in line 10, and you talk more, and then you go down to the bottom. You go down to line 20, and you testified, we cannot tell by this particular artifact what time that search occurred. Did
Absolutely.
I read that correctly?
It's specifically pertaining to that particular artifact that in browser state DB that does not tell us what time a search occurred. That is correct.
Right. So you stated, and it was your statement then, we cannot tell by this particular artifact what time that search occurred, correct?
That particular artifact.
Okay, so now let's keep going.
Mm-hmm.
Every time she says "good boy," great job.
If you go to page 129 of this transcript.
I'm there.
At the top.
Sure.
Line 1. 227 isn't necessarily one time when the tab was closed. That's in my report. I say it's undetermined. Remember we were just reading your undetermined in your May 23 report?
Correct.
Because there's a lot of things that can cause that time stamp to be there, including tab being moved, tab being minimized. The next sentence. I don't know exactly what caused the tab to get that particular entry, but it's not, that timestamp is not indicative of the time of the search or any URL that's visited. But the first part of it is, I don't know exactly what caused the tab to get that particular entry. Did I read that correctly?
You read 100% correctly.
Thank you. Now if we could turn to page 130 of your testimony.
She watched the Depp trial right before this in preparation. Did I read that correctly? We're going to the sidebar. Apparently the goat scream is too much. I'm sorry, Mr. Brennan. I will not do the goat scream during the sidebar. You're 100%. You got an A. Good job. You're improving. I'm really proud of the effort you're putting in today. You've been practicing, and it shows. It's a wee bit condescending. Just a teensy smidge. Oh, man. I love it. I love this exchange. She's doing a great job. She's holding her own. Her explanations are good. That it is cherry picking. He's trying to extract little tiny bits, and make them into something that might be a little more than they are. Catching her on a typo. For her to double down and say it's a typo, come on. Own one or the other. Either say either one's correct. Both are acceptable. But I should have put UTC. It's a typo, but it's still correct. Then it's not a typo if it's correct. Most Improved Student Award. Oh, man. Teensy like the Grand Canyon. Oh, my goodness. Oh, my goodness. Even my typos are accurate. Phil, 2IO Toys puts out on Twitter just now. He says, who used the pizza analogy better? And he went all the way back to the billing guy who winked at jurors in the Maya trial and this witness. He's got side-by-side pizza analogies. That's great, Phil. The database of video you've got at your fingertips is fabulous. All right. See, but it's not correct. 11:23 UTC is 7:23 Eastern time, so it's not even correct. Nothing like it. I get that it's 6, and you have to. I think you have to consider the time of the year. It was as well, because I think there was a shift, daylight savings shift in there, and that's why it would be accurate. You've got, if you put the date in your calculation to show that it was January 29th, 11:23 UTC converted to Eastern time, then you're going to get to the 6:23. Let's see. Oh, math. Yes, it's the bane of my existence, math. I had to use Grok to do it. I couldn't count on my fingers, to 5. I understand that you believe that it wasn't searched at 227, but do you understand the argument the defense is coming up with? No. I've seen this one several times, Dog Lover. Yeah, I see both sides. The defense is trying to show that there is doubt, and that basically the explanation was created after the problem existed. And part of the explanation was, well, in Celebrate, we're just going to not show that anymore because that's confusing. I think the jury needs to know that. I think they get it. Cindy's getting some Johnny Depp vibes. Who's a good boy? Yes, that's so good. Oh, I liked her parting shot, smiling at the jury. She's keeping an eye on the jury. She's also keeping an eye on Brennan, glancing over at the prosecution periodically. Let's see. Frosty Jen, great to have you here. Thanks for popping in chat just for a minute. We love our lurkers as well. Oh, we're back. I wonder what the objection was.
Thank you for your patience, Ms. Hyde.
Absolutely, sir.
No one wants to
what
waste
I'd
your
like to do
time
is to
like
go
this.
back to your testimony in the first proceeding, and we can go back to page 1-30.
I am there.
Thank you.
He dialed it down a ton.
I am going to
His tone changed
go back
entirely.
just because there's been some time and give some context. So we're talking about the 2:27:40 a.m. timestamp, correct, at this page location?
We've been talking about that for several pages. Yes, that's correct.
You're absolutely correct. We've been talking about it for several pages. And bear with me, I think this
No
may
problem.
be either the second to last or the last. So there you testified with regard, this was when you're referring to an artifact. You've agreed that timestamp is a fair synonym. You say on line 5, that means it wasn't in the regular database, it was in the write-ahead log. And to Celebrite's credit, that tool actually parsed the write-ahead log and displayed it where the other tools did not. So did I read that correctly, number one?
You read it correctly. So
am I correct that here what you're stating is Celebrite was actually showing the 2:27:40 a.m. timestamp at that time during your testimony in the first
on
proceeding?
that date, that is correct,
Okay,
yes.
so I just wanted to establish that, and
Absolutely.
you were giving Celebrite credit for actually showing that timestamp at that time of 2:27:40 at the time of your testimony back in June of 2024, correct?
That is correct.
Okay, so now let's go to page 1-36.
136, you said?
136, yes.
Thank you.
And on line 12, you note that Celebrite and Magnet Axiom, and then you elaborate, both Celebrite Physical Analyzer, which is a specific tool, right, of
Correct.
Celebrite, and Magnet Axiom, another specific tool, correct?
Correct.
Both have file system viewers that then have SQLite database viewers. And you, skipping down to line 17, you talk about they don't allow for deep analysis of the write-ahead logs, which is why in my analysis I use the specialized Sanderson forensic browser for SQLite, correct? I read
That is
correctly?
correct.
So is it fair to say that what you did up to this point in June of 2024, with regard to the 2:27:40 a.m. timestamp on January 29, 2022, you applied a variety of tools to analyze the issue of when did the Google search occur that you use the words associated with a Safari Google search, House Long to Die in the Cold?
There's a little bit of wording I would correct there if that's okay.
Right, but so let me see if I can ask the question
That'd be great.
a different, more simple way.
Thank you.
You're welcome. So you used a variety of tools to analyze that House Long to Die in the Cold search, correct?
Plus manual analysis and testing, yes.
Plus manual analysis and testing. Alrighty, now let's leave the testimony.
Okay.
And let's go to your next report. And your next report is December 2024. Do I have
it correct.
chronology correct, Ms. Hyde?
That is correct.
So in December of 2024, just approximately 6 months ago, you issued another report, correct?
That is correct.
And you got the request for that report also from the Norfolk District Attorneys, correct?
That is correct.
And you state in regard, well, that report regarded the analysis of the same timestamp, correct?
Correct.
To 22740 timestamp. And in that report, under relevant findings, you state, and this is December of 2024, so it's from your May 2023 report, it's approximately a year and a year and a half. Is that approximately from your May 23rd report? Approximately a year and a half?
Yes.
So a year and a half after what we just reviewed in your May 23rd report, and then just months after the testimony of June, right? So about 6 months after your
6 months later.
June testimony that we just went through, you went and looked at this issue again, correct?
That is correct.
And isn't it correct that when you were asked to look at the same timestamp in December of 2024, that Celebrite removed the timestamp from their tools?
Celebrite did remove that timestamp from the tool. That is correct.
Okay. And that timestamp was the subject of extensive reports and testimony that you participated in the first proceeding, correct?
That is correct.
And even though that timestamp, 2:27:40 a.m., that showed up in Celebrite tools, Magnet Forensic Axiom showed up, that was removed by Celebrate, correct?
Celebrite no longer reports it. The evidence is still in the data. I want to be clear, just that it doesn't change the data. They just removed it from their automated parsing and reporting.
Right, so they removed it from their automated parsing and reporting, correct?
Yes, they did. That is correct.
However, your former company, Magnet Forensic Axiom, still shows it. Yeah.
Magnet Axiom Forensics currently shows it as a carved artifact and still shows that and gives a description in their artifact reference guide as to what they believe causes that artifact.
I'm going to ask the question.
Yes, it does.
Magnet Axiom Forensics, where you used to be the director of forensics.
That is correct.
Still shows that timestamp.
Yes,
right?
yes.
But Celebrite doesn't. In the automated
That is correct.
tools.
That is correct in their automated parsing.
And you would agree that Magnet Forensics is a very reputable company, correct?
Correct.
Let's go back to your December 2024 report. Do you recall just moments ago when we went through your testimony in June of 2024 in the first proceeding where you stated various times how it was, I'll use the term best practices, to use multiple tools to analyze the timestamp?
Correct.
And you used many tools back then to analyze that timestamp. And you testified to those many tools on your direct examination, correct?
Correct, yes.
However, in December of 2024, when you returned to analyze the 22740 timestamp, how many tools did you use to analyze that timestamp? Can you give me just a number? How many tools?
At least 4.
Well, in your report, let's go to your report, what your report says.
Mm-hmm.
So in your report, you state that under relevant findings, do you not, that review of data from Celebrite shows that the artifact of a Google search from a Safari suspended state tab with the search term house long to die in cold, and I'm going to skip over, in addition to my own previous report, no longer shows a last visited timestamp.
I think that is not clear. The skipping there makes it sound like my report no longer shows that, and that's not what's
that's a fair statement. That's a fair statement. Let me rephrase it this way. You're welcome. In this report, you speak about Celebrate release reports, correct?
Are you referring to the Celebrate release notes that come out?
The release notes at the bottom, right? You referred to that?
That's correct.
And that release note states that Celebrate has removed the timestamp value from records, and I'm assuming that's a reference to Celebrate's.
Celebrate no longer parses that result. That is the statement in this report. Correct.
Right. And so I'm going to go to page 4 of your report.
For sure. I'm there.
And I'm going to go down, all the way down to the conclusion. In that report, is there reference to any company other than Celebrate in this entire report?
In this report, no.
Okay, thank you. Now let's go to your prior testimony in the first proceeding, where you said that it was important to use multiple tools.
Absolutely.
Do you still stand by your position that you've given today and that you gave in June, that it's important to use multiple tools?
Absolutely.
Now let's go back to the issue of the extraction of Jen McCabe's phone. And what I want to do is to cover a concept and see if I've got this correctly. Are you familiar with the phrase Apple source codes?
I'm sorry, can you please repeat?
Absolutely, no worries, sir.
Someone was dying there in back. Sorry.
Are you familiar with the phrase Apple source codes?
Apple's source code? Absolutely, yes.
And isn't it a fact that Apple keeps its source codes proprietary, meaning very few people have access to it?
That's correct. It is closed source is the term we would use.
Closed source.
That would be the term of art, correct.
And they keep it so close that they call it closed source.
And it's not just Apple. Lots of tools are closed source. That just means that the code isn't available like it would be for the tool I mentioned earlier, iLeap. That's an open source tool. Anyone can look at the code. For Apple, we cannot go look at the code that makes your phone run. That's correct.
And isn't it the case, and I refer to that as the MB postulate. It's a shorthanded, but I don't need to have you refer to it that way.
I'm sorry, could you repeat that phrase? I was unfamiliar with it.
I'm going to skip it.
Okay,
I'll
thank
just
you.
go on. Basically, the concept that Apple has source codes that are closed sources. So I'll just refer to them as Apple's closed sources. Wouldn't the best information about when a search occurred, what it's associated with, wouldn't the best information be in the Apple source code to answer that question?
It is acceptable in digital forensic science and in accordance with the NIST Science Foundation papers to conduct testing to determine how the functionality of something works. You do not need access to the source code to be able to speak to an artifact.
My question isn't that. My question is, isn't the best place the best place to go is to the Apple source codes themselves, or are you saying these physical analyzer tools are just as good, and the information they pull is just as good as an Apple source code?
Those are very, very, those are incongruent statements. Apple source code is not a healthy way to do an examination because it would be so onerous, and we do not know the level of documentation, we don't know the language. That is not necessarily the most effective way to determine what data is. Forensics tools parse results of how data is. They don't interpret them. The examiner interprets them and provides meaning. And I would like to state that those three things should not be conflated. They are very individual concepts.
I think you misunderstood my question.
I probably did it because that's what I was seeing.
My question is this. Isn't the best source for information about data in an iPhone contained within Apple source codes?
Not necessarily. Because that doesn't operational performance is a better source in a practical sense to being able to determine what something is, as opposed to zillions, and no, I don't know the number because it's closed source, lines of code that may or may not have different levels of documentation. Apple themselves wouldn't be able to, any individual there who has access wouldn't know every feature of how every element works. Testing through the methodologies described in NIST is the accepted methodology in our science, not reviewing the source code.
I'm going to try it a different way. I understand what you're saying is, if I got it correct, you correct me. Are you saying that these physical tools make it easier to interpret and view the data?
I did not speak about the tools at all in the statement I just made.
Okay.
I spoke about manual testing and checking the functionality and what results. Parse tools, again, these are three separate concepts. The concept of code and actually reviewing code to make a determination is different from parse tool results, is different from doing testing and validation. Those are separate concepts. They should not be commingled as if they equate to each other.
So have you ever learned of, have you ever spoken with Mr. Whiffen? Ian Whiffen?
I have spoken with Mr. Whiffen historically, but not since the term of this trial.
Okay. Have you ever spoken to Mr. Whiffen about whether the Apple source codes are the best source of information about topics like timestamps? Have you ever spoken? That's just a question.
I have not had that conversation with Mr. Whiffen, no.
Okay, all right. I want to move on to, and do you regard Mr. Whiffen as a reputable?
Mr. Whiffen is a reputable forensics examiner, and I've actually reviewed his work in other instances and peer-reviewed his papers.
So you have regard for his reputation?
I have regard for his reputation.
I'm sorry, we have to wait for each other.
Oh,
to
yes,
talk
I'm sorry.
It's all right, no worries.
She interrupts again.
So you have regard for the opinions of Mr. Whiffen generally, correct?
Absolutely, yes.
And you believe he has a solid reputation, correct?
Absolutely, that is correct.
Now let's turn to the
he says Apple source code is
History
the best place.
DB database. You are familiar with History DB? History DB, are you familiar with that phrase?
I am familiar with that phrase.
Okay. Do any of the house-long searches appear in the History DB?
In this instance, no, we do not have artifacts in the History DB of either of those two searches.
So I want to just repeat that in a different way. So the History DB, is that considered a valid and valuable source of information in an iPhone?
That is a valuable artifact for Safari history. That is correct.
But the house-long searches we've been discussing do not appear in that History DB, do they?
That is correct.
Why?
You spoke about PYF, PDF on your direct testimony. Do you recall that?
I do. It's the Python framework for PDF. It is a GitHub tool, one can download from GitHub to utilize to create PDFs using Python code. So a developer and a tool would integrate that to create a PDF.
And the PYF PDF can have the variables set, correct?
Yes, the Python script allows the developer to set things such as their name that they created the document. Yes.
I want to go to the extraction of Jen McCabe's phone that you talked about on direct examination. Is the hash value signed or unsigned?
A hash value isn't signed. I believe your question you're asking me is if the Adobe document that contained the PDF that contained the hash values? Are you asking me if that's signed? Because a hash value is something that matches. A hash value isn't signed.
Let me ask it this way. Is there any hash value associated with Jen McCabe's phone that is unsigned?
That is not a valid question. I apologize. We don't refer to hash values as being signed or unsigned. We would refer to the PDF that contains that value as being signed or unsigned.
She's smart.
Have you ever read a report of Mr. Ian Whiffen in this case?
I have, but I have to be clear. I have not read all of Ian's reports. I've only read some, so I don't know if I read some of his earlier reports.
Do you recall reading a report of Mr. Whiffen where he references a hash value being unsigned associated with the iPhone of Jennifer McCabe?
Can I see said report so I can validate if I did or did not? I'm not sure based on just that, because I wouldn't use the term hash value being signed. I did see a report in which Mr. Whiffen spoke to the PDF not being signed.
She's really smart.
I just want to try to shortcut this and work off your last statement. You're now saying you do recall seeing a report of Mr. Whiffen where he said a PDF was unsigned?
I need to see. I do remember him referencing the PDF. I would need to see the report, especially since the characterization of hash value being unsigned is not a term of art that I am familiar with in our field.
Let me ask if you agree or disagree with this statement. This value can be used to compare with the original hash calculated at the time of extraction in order to validate the extraction data. However, this requires authentication of the original hash value, which is not possible with gray key extractions, as the PDF containing the extraction hash value is unsigned. Therefore, this hash value could be used as a suggestion of authentication, but cannot be guaranteed 100%. Do you agree or disagree with that?
His statement there says the PDF is unsigned, not that the hash value is unsigned.
Right, but it's nonetheless unsigned, correct?
The PDF is not signed. That is a correct statement. Gray key PDFs that purport that value are not an Adobe signed document.
Do you know the history of the extraction of Jen McCabe's phone? Yes or no?
Can you provide more clarity? What do you mean? Do you mean from the time the image was made? Do you mean from the time the device was received? Because I don't know the information pertaining to the receipt of the device into evidence, and then when I only have the documentation of the image forward. So I want to be clear about what period we're talking about.
It's an excellent point, and I am going to follow up with some questions.
Okay.
In an extraction, doesn't the extraction from a phone start with the raw data, raw image? You tell me, when someone brings a phone in, what's the first step that gets taken in order to do a full file extraction? What's the first step?
It depends. There's got to be steps with regard to network isolation. I need to know if the device is AFU or BFU at that point. So I don't have that information from this case, if that is the question. I get from the image forward.
So what I'd like to do, and this may be my last section of questioning, I'd like you to describe the ideal situation as to getting the most reliable data from an iPhone from the start. What's the most reliable way to do it?
I would say the most reliable way is following the recently released SWIG-DE Scientific Working Group on Digital Evidence document on best practices of evidence handling, preservation, and imaging. I may have that title slightly out of order, but it is a document released this January.
And tell me what that is.
Sure. In that, the first thing, from which point are we starting? Are we starting like extracting the data using a tool, or are we talking on scene, taking the device into evidence?
The latter.
Okay. So the first thing you're going to do is you're going to ensure that you are isolating the device. This is also going to depend on condition from the network. So typically this would be done with a Faraday enclosure in a best practice. However, there are alternative ways of isolating from the network, such as disabling all of the communication protocols, such as Wi-Fi, airplane mode, etc. The next step, once you've isolated, but prior to, you also want to make sure you're continuing battery stat. So if a device is on, you want to keep it powered on. If it's off, you want to keep it powered off. That's a general statement. So the best way to do that is to attach a battery charger. Just like when your battery runs low, you plug in a charger in the back of these battery packs. We do that with that before we put it in the Faraday bag. A Faraday bag is an enclosure that blocks signals from coming to the device. This is so a remote wipe command couldn't be sent, or so that more data isn't received to the phone.
It's like
because
a tinfoil
phones are
hat,
live
but for your
and
phone.
constantly obtaining data. So we're going to have it with a battery pack in a Faraday, presuming it was on. Again, I don't know the status of this device. The next steps are going to depend on what state that device is, and what make and model that device is, and what the current support for that device is. There are multiple types of extraction methods of phones. In the modern day on iOS, a full file system image, what we had on the devices in question in this case, is considered the gold standard because it has the most robust information. So at this point, the next question is what's the best image type? And that's going to depend on if we have a passcode or if we don't have a passcode.
If I could,
please.
And I'm going to allow you to continue.
Yeah, please.
I want to break it down for the jury. So what I now want to do, you've stopped at a certain point, but you've talked about securing, what I would call securing the phone, right? And then making sure that there's no data swiped. You talked about airplane mode, Faraday bag, Faraday box, right?
If you don't have a Faraday box.
Do you know whether any of those protocols were followed for either the iPhone of Jen McCabe or John O'Keefe?
As I mentioned, I was not there for those processes. I don't have documentation of it. As mentioned, what started where my receipt of the device is from the image.
Exactly. So you don't know.
I can't testify to processes I did not or was not available or aware of.
Fair enough. But do you have a little bit of hint as to whether the phone of Mr. John O'Keefe was properly secured in airplane mode, a Faraday bag, or a Faraday box, based upon your own report of the iPhone of John McCabe? Can you determine that from page 5 of your report?
Obviously, there is data signals that are still being made and created. I believe that is what you're referring to. So the assumption is that I don't know at which point a Faraday bag is employed, but I also want to be clear, I don't know when, I don't have information outside of the digital forensics realm about this case, so I don't know precisely when the phone was taken into custody by law enforcement.
Fair enough. So assume that Mr. O'Keefe was deceased around the latest 9 a.m. on January 29th, 2022. Isn't there activity on that phone, health data activity, up to around noon of January 29th?
Health data activity would continue to be reported regardless of if the device was isolated from the network or not. Health data has to do with the movement of the device, so if the device was being moved even within a Faraday bag, that data would still be populated.
How about location data?
Location data is unlikely to be reported in a device that is Faraday enclosed, but I do not know what location data you're referring to, so I cannot speak in absolutes without having a better reference to the artifacts in question. If you're saying it's in my report, I'll look at it, but again, I never knew when the phone was seized, so it was not part of my initial analysis. Do I have permission to look at that time, Nick? Yes. Thank you, Your Honor. So bear with me. It's a big report, as you know.
It is a big report.
And it was at the bottom of my stack.
Pardon me?
All right. It was at the bottom of my stack. I had to lift up the other ones to find it. All right. So,
Your Honor, may I assist and point her to a page?
Sure. That'd be
Thank
great.
you. If you could turn to that report on your page 47 and continue on to page 50.
I do see incoming data that is consistent with the device not being Faradayed, such as the receipt of SMS messages, notifications from Ring, etc.
So, the iPhone of Mr. O'Keefe was not secured in the manner you described before we got to this, as would be the best practice with regard to getting the most accurate data from a phone. That is, once it comes in, that it's to either be put in airplane mode, Faraday bag, or Faraday box. Is that correct? By your own report, you see activity.
I do see activity. It was not Faradayed. Faraday prevents wiping of the device and additional data. So actually, in this instance, it doesn't appear that the device was at risk of wipe because it was not wiped. And we actually have more data because we get to see the data that continue to come into the device. I'm not saying that's in accordance with best practice. I'm saying that that's what I see based off of what you just had me review in the data.
It sounds like you're trying to justify.
Oh, I'm not trying to
right or
justify.
Wrong, you tell me. It sounds like you're trying to justify the fact it wasn't secured. Am I correct? Or
No, you're incorrect. I'm just stating we have, you asked if we had more data or less data. We actually have more data with it not being Faradayed. But no, best practice would be to Faraday. I 100% agree.
My question wasn't, is there more or less data? My question was simply, doesn't your own report show activity up until noon on January 29, 2022?
Correct. And for clarity, my scope was till noon, so I don't know if there was activity beyond that.
Right, but as far as your scope goes, I want to be clear.
Yep.
There is activity on this phone.
Absolutely.
Which shows that it was not put in airplane mode, it was not put in a Faraday bag, and it was not put in a Faraday box. And that failure is not best practice.
Correct. It is not in accordance with the best practices. I agree. I would have Faradayed it.
Thank you. So
that was not hard.
If I,
that's okay. I have no further questions. Thank you for answering my questions, Ms. Hyde.
Thank you for your questions. Have a great day.
We appreciate your business. Look at that. The judge rolls her eyes nearly. She's like, oh my goodness, this is terrible. No questions. Brennan is waiting for Mr. Alessi to clean up his crap off the podium.
Of course.
Fun witness. I think she held her own. She's a smart lady. She's really smart. A little stubborn about some things that I think she should have just said yes on, but smart lady.
You were asked when you began working on analyzing phones in this case, and you said it was in May. Was that of May of 2023?
May of 2023. May 4th, 2023 is the email I have of a note. Thank you. Yes. It's easy to remember because May the 4th be with you.
When you first were asked to begin work on this case in May of 2023,
Star
what was
Wars.
the catalyst for you to begin working on this?
I was contacted by Mr. Tully and then contracted, a SOW was signed, and I began work on the initial request to look at those two search terms on January 29th. Does that answer your question?
Sure.
Okay.
Was there a certain claim that was lodged that you were to focus on?
I was to focus on the two search terms from January 29th, 2022.
And were you informed why? Was there any context to that?
Probably. I don't recall the exact conversation that I had with the DA's office and Lieutenant Tully at that time, but I'm assuming that I was given that context. I have in my notes that I was to look at those two searches on that date and do an analysis about those.
Were you asked to reach any particular result?
No, I was asked to provide my report, not to reach a particular result.
Were you asked to reach a conclusion that the 227 timestamp was inaccurate?
No.
When you engaged in your analysis, was it independent of the district attorney's office?
My analysis was independent of the district attorney's office. I actually, in the first case, had very little communication with the district attorney's office during the period of my analysis.
Was there any input from any outside source on what your result or ultimate opinions would be?
No.
Would you ever allow anybody to affect your input?
No.
Throughout the course of your efforts with this phone, have there been changes to software?
Absolutely. As mentioned on direct, software updates are near monthly.
I want to ask you about changes to the Celebrate software. You were asked about certain reports you wrote. Were the reports that you wrote relative to different requests for analysis?
Yes.
The report regarding report number 3, regarding changes to Celebrate software, was that report limited to the timestamp change, or was it to include other efforts?
The scope of that report, may I review what I have documented as the
Please.
scope? I believe we're talking about report 2. That's the one about the Celebrate change?
Yes.
And I have the request was to understand changes made in the newer version of Celebrate Physical Analyzer to artifacts pertaining to the timeline of a particular Google search on January 29, 2022, namely how's long to die in cold.
When you looked at the Celebrate software and report, was the timestamp characterization changed or removed?
Yes, it was removed. That timestamp in the version starting in May of 2024, Celebrate actually removed that, and they put a release note stating that it was due to the ambiguity and potential for misconstruing the meaning of that data.
Was there any other releases informing other reasons why that was changed other than the potential that somebody could misconstrue, misinterpret, or distort the information?
Can I read Celebrate's own statement?
Please.
Celebrate's statement in...
To yourself.
To myself? Okay, roger that. Thank you. I appreciate that.
Roger that, Judge. Copy. That's a 10-4, good buddy. Over and out.
Can you repeat the question?
With us, was there any reason other than the concern about misinterpreting or distorting?
They said that
She's reading it again.
my understanding is that it is not a reliable timestamp, and that is why Celebrate removed it.
You were asked about Axiom. Axiom, is it the same or different?
Magnet Axiom and Celebrate Physical Analyzer are two different tools that both do forensic analysis of mobile phones.
You were asked whether Axiom still has a timestamp that was similar to Celebrate before the change.
Axiom shows what I spoke to on direct, where they have it as a parsed versus carved result. And so that particular result shows in the suspended StateDB artifact as carved.
Do companies like Axiom and Celebrate give releases, updates, information about how to interpret their reports?
So Axiom actually has a document that's released with it called the Artifact Reference Guide, and that actually gives a brief description of the fields and of artifacts. All tools, when they release new artifacts, they put out in a release note. Not all artifacts are clearly documented that are parsed. However, all of the vendors regularly put out webinars and blog posts that explain their new artifacts, but not necessarily all.
Is there any releases or cautions from Axiom on the same issue about misinterpreting a timestamp?
Axiom, in their artifact reference guide for this artifact, does speak to the possibility of misinterpretation and states that the timestamp can be earlier than the search had occurred, based on what different reasons could cause that timestamp.
Let me ask you about a Faraday bag. You said that best practices is to isolate an item in a Faraday bag.
That's correct.
Do you have any information, or did you know the travel of Mr. O'Keefe's phone that night or where it went after?
I'm sorry, can you clarify the time period?
On January 29, 2022, from, say, 6:04 in the morning until later that afternoon.
I did not have access to that information.
When you analyze data from certain devices, are they always placed in a Faraday bag immediately after an incident?
There's a lot of times when this is situation dependent. An example of when you would not put something in a Faraday bag is when you have a deceased victim and you're going to be using their biometrics to possibly unlock the device. Because a Faraday bag is enclosed and then can't be opened, if your intent, if you don't have the password, is to use a deceased person's fingerprint to unlock the phone, we don't want to put the person's finger in the Faraday bag, so usually those phones would not be Faradayed, but they would typically have airplane mode enabled or SIM card removed. But no, SIM card removed doesn't actually work on iOS, so I won't get into that.
Understanding or having the opinion that this item was not placed in a Faraday bag at 6:04 in the morning, does that in any way affect your opinions about the data that you analyzed on this phone and the conclusions that you reached regarding Mr. O'Keefe's phone?
It does not have any impact on the conclusions other than the fact that it wasn't Faradayed and more data came in. So we have additional data.
You were asked a very specific question about History DB, and it was simply whether or not How's Long to Die in Cold, whether it appeared in History DB. That isolated question, does that provide any context for you and your analysis and conclusions about How Long to Die in Cold and that it occurred at 6:23 and 6:24 the next morning?
The absence of the History DB artifact doesn't mean that that search didn't occur at that time. We have multiple corroborating artifacts, which is usually what we look for, 2 artifacts that demonstrate is like very good. You don't necessarily need that, but in this instance, we have both from the Mobile Safari plist, which tracks the history, as well as the Knowledge C DB. So we do have 2 artifacts showing that those searches were done at that time. Of course, 6 seconds apart for the difference between the Knowledge C and the Mobile Safari plist.
On direct examination, you were not asked questions about Mr. O'Keefe's phone.
That is correct.
You were on cross-examination, so let me follow up. You have a report that you authored regarding Mr. O'Keefe's phone?
That is correct.
And you had an opportunity to look at the healthcare data for January 29, 2022.
That is correct.
Page 6 of your report.
Thank you.
Does a martini shaker work as
You
a Faraday
noted
cage?
that there were steps that began at 12:11:09 a.m. Is that accurate?
That is accurate.
And the way healthcare data works, do you have an understanding whether steps means a person actually took a number of steps, or does it mean something else?
Steps doesn't necessarily mean that you took a number of steps. It's based on the motion of the device. So it could be steps, it could be you're carrying it, it could be that you're in some other kind of motion, you could be on a bicycle, you could, any number of things. And the number of steps is based on the presumed gait, based on the input into the Apple Health app in terms of gender and height. So it determines a gait and then prescribes a number of steps, but it is possible for other things to cause steps to occur.
You were asked specifically if you saw that there were reported movement or health steps at 12:21:10 a.m. and specifically pointed out to you notation or characterization of 80 steps. Is that accurate?
That is what's stored in the database. I try to clarify, as I did for you, sir, that that's what's stored in the database. I'm not saying that 80 steps were taken.
And by the way, in addition to the healthcare analysis, you did some analysis on the movement of a car, didn't you?
For Ms.
Your Honor.
Late breaking.
I'm going to deny that question.
Late breaking.
Can these health
objection
steps occur if somebody's holding a phone while traveling in a car?
As mentioned in my report, it's caused by motion. It could be various motions that could cause it. You could be using an elliptical, you could be in a vehicle, you could be on a bicycle. It's not necessarily steps taken.
Based on your analysis of Mr. O'Keefe's phone and the report that was pointed out to you in cross-examination, and do you have information or opinion where Mr. O'Keefe's phone was located around 12/21/10 while those steps registered?
Objection, Your Honor. So,
That's beyond the scope of the process.
It was pointed out to you at 12/21/10 there was a registered 80 steps. Is that accurate?
That is correct.
Okay. And then you were also asked about the last healthcare data, the last movements of this phone. And it was pointed out that that began at 12/31/56 for 20 seconds?
That's correct. Per the data in the database.
And is that the last movement of Mr. O'Keefe's phone that evening before 6:04 that you saw when you analyzed the entire data in the phone?
May I have one moment to review?
Yes.
Other than the lock button, right?
That appears to be the last before the 6 a.m. hour.
And so that 20 seconds, if it began at 12/31/56, what was the last movement in seconds in time at that time of Mr. O'Keefe's phone?
I'm sorry, can you repeat?
Yes, if that was a 20-second interval at 12/31/56, what was the last second that evening that Mr. O'Keefe's phone moved?
12/32/16.
Is that your final
And
answer?
then when you analyzed the phone and were asked about these times, is there any movement between that last movement and 6:04:01?
Between the 12:32?
Yes, 12:32:16 and 6:04:01. Any movement of that phone whatsoever?
I do not have anything supporting that in my report.
Do you know what was going on with Mr. O'Keefe's phone at 6:04:01 a.m. on the morning of January 29, 2022?
I do not know precisely what was happening with his phone at that time in terms of movement. If that's, or are you asking me? I'm sorry. Can you clarify what you mean
Yes.
by the question?
The next movement after 12:32
Is the 6:04.
6:04:01
Correct.
a.m.
Correct.
Do you have any information about where or why there was movement of the phone at that time?
I don't. That wouldn't be inside my digital evidence, I don't believe.
And the last question is, the next movement at 6:15:14, do you know if that phone was being moved by somebody or somebody else than Mr.
The
O'Keefe?
phone was in motion. I do not know if it could be by a person, it could be on a rail car. I don't think it was on a rail car for clarity, but I don't know what is causing that motion at that time.
Could have been with the
Thank you very
pizza
much.
on the restaurant. Going back to the chef.
we have a moment, Your Honor. Excuse me, Mr. Brennan. Your notes.
Oh, thank you.
Mr. Brennan, here are your notes. Thank you, he says. What was that? Woody the Woodpecker.
Ms.
just making
Hyde,
appearance.
you were asked questions by Mr. Brennan just moments ago about Celebrite and release notes. Do you recall those questions?
Yes.
And did Celebrite,
Sirens.
beyond stating that their opinion was the 2:20:40 a.m. timestamp was not reliable, did they give any reason at all for why they concluded it was not reliable in that? I'm sorry, we'll wait for the...
Thank you. I appreciate it.
Yep. And I'll repeat the question.
I hear two.
Thank you.
Fire truck has a woo. And the woo, 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 woo. A separate one. Just two. Yeah, we hear you. We hear you. I'm sorry, jurors. No one wants it to waste your time like this.
May I, Your Honor? Thank you. In that release note, does Celebrite state any reason for why they wrote not a reliable timestamp?
There are other
I'm sorry, my
but
question
not
is, do they
Celebrite?
state in the release note whether there's a reason for why they concluded?
May I look at the release note, ma'am? Thank you, ma'am. Thank you, Your Honor.
And please try not to talk.
I will,
Sorry, Your Honor.
Thank you.
2.
Not asking you to read it, just asking whether or not they give any reason for the conclusion not a reliable timestamp.
One moment, I'd like to review what they wrote. Thank
Absolutely.
you.
You're welcome.
Yes, they do. They state that further research since is the reason that they're doing it, that there's further research.
Did they state what that research is?
They don't, but
All right, but they don't state what the further research is.
that is correct. They
All right,
state
now
that
what I'd like
it's
to do is
unreliable.
move on to Axiom. You were asked questions by Attorney Brennan, and you referred to Axiom as using a different parlance with the timestamp of carved, correct?
Celebrite uses this deleted demarcation or recovered demarcation. Axiom does not do that at all. They speak to how they recovered the artifact, be it that it was parsed. When I say parsed, I mean the item was where it was expected to be in the algorithm, found it, located it, and said it's here, versus carved, which is when they have to go into an unexpected area, such as slack space, which would be the areas that are not yet used or were previously used to extract the data from that.
So Axiom actually recovers the timestamp, but Celebrite does not. Is that correct? Is that correct?
Yes,
Okay.
currently, previously, when we did the first case.
Right, but
It's the
currently,
opposite.
Celebrite
Correct.
doesn't, but Axiom does. Axiom recovers 2:27:40 a.m., correct? Timestamp? They
That
recover.
is the timestamp that they show for that artifact. Correct.
Exactly. So now I'd like to go back to the next topic, our discussion about Mr. O'Keefe's phone and secured or not. You talked about one example of maybe needing to use a biometric to unlock a phone, and that might be a reason, as I understand it, as to why someone might not put it in a Faraday bag or box. Do I have that correct?
Correct.
Okay, do you know whether the passcode was immediately provided on the phone of Mr. O'Keefe?
I do not have that information.
Assume that the passcode was immediately provided for the phone of Mr. O'Keefe. Can you think of any other reason why that phone wouldn't be put in airplane mode, Faraday bag, or Faraday box?
Best practice would be to put it in a Faraday bag.
Okay. And that phone was obviously not put in airplane mode, Faraday box, or Faraday bag after 6:04 a.m. on January 29, 2022, correct?
Correct.
Now let's go to...
Well, I don't know if at some point past 12 o'clock. My report only goes to noon, so just for clarity, I don't know
Fair enough.
anything past noon.
Fair enough, but from 6:04 a.m. until approximately noon
Correct.
on January 29, 2022, at least that time, that phone is not in airplane mode in a Faraday bag or a Faraday box, correct?
It would appear such. Because I didn't analyze past that, I don't know if it had been potentially Faradayed and then it broke Faraday and got data, but I don't suspect that based on this. It appears that that data was live. But I just have to speak to the fact that I just don't know because I didn't go past noon.
Right, but you're going past noon.
Right.
I'm not.
Okay.
My
yeah.
question,
6 a.m. to noon, it does not appear to be Faraday.
So to be clear, from 6:04 a.m. on January 29, 2022 until at least noon of January 29, 2022, the iPhone of Mr. O'Keefe is not in airplane mode, it's not in a Faraday bag, and it's not a Faraday box, correct?
Unless it was in a broken Faraday bag, like they put it and it was failing. But yeah, it does not appear to have been placed in Faraday bag.
All right.
No, I'm just being honest. You should test your Faraday bags. They go bad. I use Dr. Katz's testing methodology, but 100%, it appears to have been receiving signal for that entire period and not in a Faraday bag, which would be best practice unless biometrics were needed.
So let's now go to hopefully what are the last two categories of questions. With regard to the iPhone of Jen McCabe, do you have any knowledge as to whether over 200 calls were auto-deleted on her phone? You analyzed it.
We can see that calls were auto-deleted. You're asking me if the number of, I just want to make sure I understand the question, if the number of calls that were auto-deleted, if that exceeded 200?
My question is, do you know whether there was auto-deletions on Jen McCabe's phone? Do you know that?
I'm uncomfortable with the term auto-deletions because I don't know what that is inferring.
Okay. Did you analyze her phone at all for deletions?
I analyzed her phone to see if there had been deletions of call logs, and what I found was that there were records that were removed by the system and not recoverable from that database, but were recoverable from biomes.
Understood. Now what I'd like to do is to address your answer in response to Mr. Brennan's questions, where you said that the issue with regard to Mr. O'Keefe's, or just generally your proposition, that there was no impact on your conclusion because more data had been obtained. Did I get that correct?
I believe my statement was there was no impact on my conclusion with the fact that it had not been in a Faraday.
Right. So isn't it, though, the case that when a phone's not in a Faraday and is therefore active, data can be overwritten?
Yes.
So if data can be overwritten when it's not in a Faraday, you can lose that data, correct?
Is there data that we're concerned? Yes, theoretically.
Right.
Yes.
You talked about, in response to Attorney Brennan, the 12/31/56 steps, and you said the last, according to you, last movement 12/32/16. Do you recall those questions?
I recall the questions.
Yeah. To boil it down, isn't it correct that that phone was moving at that time?
May I check the timestamp again?
Absolutely.
I apologize. There's
a
lot of timestamps going back and forth.
Please do.
12/31/56? Is that
that's the start. Yep.
Oh, yes, this one there definitely is. Yes, yes, yes.
So, doesn't matter what kind of movement, but that phone was moving starting at 12/31/56 and still moving until 12/32/16 a.m. on January 29, 2022, correct?
Yes.
Thank you. Appreciate again your answering my questions.
Thank you.
All right, Ms. Ayden.
What was that last?
Thank you, Your
It was
Honor.
still moving until when?
Can I see counsel about scheduling? Or feel free to stand up and stretch.
Let me see if I can bring in that last answer. And of course I ran out of space on that file. Bring in the new one. to hear what his question was.
22, correct?
Yes.
Thank you.
Definitely is. Yes.
Okay, here we go.
So, doesn't matter what kind of movement, but that phone was moving starting at 12:31:56 and still moving until 12:32:16 a.m. on January 29.
Got it. Okay, we're back. A little more redirect, maybe? No, she's done.
May I?
Yes.
I would like to play clip 15, please.
15, another video.
Absolutely more than Jen McCabe. Jen McCabe, it's me or her. Either I'm going down, Jen, or you are.
Okay. All right. So,
Flip a
folks,
coin?
I
Is that
talked
the-
to the lawyers briefly about scheduling at sidebar, and I'm told we're actually ahead of schedule. So with that, rather than beginning a witness who's probably going to take a while, we may as well let you go and enjoy the rest of this beautiful afternoon. So
It is
we're on
a beautiful
schedule,
afternoon.
Ahead of schedule. We'll reevaluate that tomorrow. Now, you will see the lawyers at sidebar as we do as well about to talk a little bit about scheduling. Those same cautions, please. Do not discuss this case
Discuss
with
anything.
anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it and let us know. And be very careful with your social media use. We'll see you tomorrow morning. Thank you.
All rise for the court, please. Closing notebooks to follow me.
All right.
Come on up.
What? Oh, why don't you come on up? I think she said. Why don't you come on up? All right. Either Jen McCabe's going down or I am. It's either you or me. Let's see who's going down. Vote Jen or Karen. Too early for the vote. But I think we are going to just take a quick glance around the courtroom. There's our tech support for the fence with all the computers. The Fiji water bottles littering the table of defense. Who's this guy? I think they're baiting her, BG. I really think they're baiting her. See Paul in the back row there. Have not heard from him yet. Do expect to at some time. Peggy's here as well. Those benches are not comfortable. Very wise to bring a cushion. I was an appellate lawyer. Yeah, he's like, well, my work starts today. Yeah. The clips can be put into context by Karen herself, so no appeal issue. The problem is she has to testify to do so, and that opens her up to cross-examination. She can't just play the rest of the clips to put them in context. Defense can't. Let's see. She better not testify. I don't think it's a good thing for her to do it. I think Mr. Brennan would eat her alive. Can't they use rule of completion to play it all? This is the thought I had. Why don't you ask for rule of completion? Couple scenarios. Either it's not out of context and it's just as bad as it sounds. So context doesn't fix it. Context is worse or makes it look worse. So it's we'd rather have it limited than have everything in. Maybe the judge ruled no. Because when this first came up, there was an argument, and the judge says, "You'll be able to clarify it. You'll be able to play what the parts you want in your." And Mr. Brennan's like, but no, not without her testifying. So I think that is the goal. Prosecutor doesn't have to play it all because it's statements against his interest, but rule of completion should still apply a little bit, especially with how short some of these clips are, just mere seconds. What happened to the female attorney that was a juror? I think she's here, but with the family. There's just no room. It's such a small courtroom. Look at all the cases. I mean, look at the ground here. They've got binders and computer cases and I guess even suitcases. There is no room in that courtroom for anybody else. Nope on the rule of completion. So where would the rule of completion come in? If not for this. They're at sidebar right now. I believe they have finished for the day. The jury has been released, so anything else that happens here will be just a little discussion between the lawyers and the judges, lawyers and the judge, and we expect to be done here in just a second. Massachusetts has rule of completion. Maybe we should research this just a little bit for why it's not applied here. In Massachusetts, the rule of completeness, also known as the doctrine of verbal completeness, allows for the admission of other relevant parts of a statement or writing when a portion has already been introduced as evidence, if those other parts help clarify the context of the admitted portion. This rule ensures that the fact finder, judge or jury, isn't misled by a statement taken out of context. So you've got the purpose aims to prevent parties from misleading the court by selectively presenting parts of a statement or writing that are taken out of context. When a party introduces a part of a statement or writing as evidence, the opposing party can then introduce other relevant portions of the same statement or writing to clarify the meaning and context of the admitted portion. If that's what defense is counting on, and the judge is going to allow that without her taking the stand, that would fix it. The additional portions must serve to clarify the context of the admitted portion, ensuring the more complete and accurate understanding of the statement or writing. If a witness testifies about a specific sentence from a written agreement, the opposing party could introduce other relevant clauses of the agreement to demonstrate the overall context and meaning. It has its roots in common law principles of evidence, ensuring that the fact finder hears the complete picture of the statement or writing. That's Section 106, Doctrine of Completeness. Got a phone call. Hang on. I think that was AWOL, and he just hung up on me. I was not quick enough. Let's see. Brady, thanks for pointing this out. We got about 625 likes today. We've got about 2,000 people watching currently. I'm not asking you to like in case you liked the testimony in court or liked a witness or liked an attorney. But if you do like the channel, I'd appreciate a thumbs up. That would be great. It is free. Can they put their on their stand and ask, is this your interview, then play it all and not ask any questions about it? Would prosecutor be limited and not ask about it to not? No. If they put her on the stand, the prosecutor is going to get a fair shot at Karen Reed. At pretty much everything. I don't think you could just say, what's your name? Karen Reed. Did you do it? No. No further questions. They can't they can't tie the prosecution like that. That they won't be able to do that.
Thank you.
Oh, we're back.
I'll see you tomorrow morning. Just have to sign my signature.
She says we're done. See you tomorrow morning. We gone. All right. What about the scope? I believe the prosecution would be given a fair amount of latitude to go outside of scope in that case, and probably be able to ask questions about various things that were already in evidence. They'll never get completeness, though, because of our interviews have been on 1 hour, 20, 48 hours, all those sorts of shows, and Bev said whole videos cannot be played. Thankfully, because everyone would get a copyright strike if we played the whole video. There's no way 48 hours would just be like, yeah, you can all re-air our stuff on your channels. That would be bad. Nicole, this is what I'm thinking. In truth, Karen's not good at making public statements, and this is not anything against Karen. There are some people who are good at this and some people who are not. I don't think Karen's good at it. Being on the stand, testifying as a witness would fall in that same category for me. I don't think she's good. She would, her answers, I don't think would be measured appropriately, and she could get herself in trouble very, very quickly, especially because this is so personal to her. This is about her, and being able to keep your emotions under check when confronted by a very hostile attorney, which Brennan would be if he questioned her. He would get her spun up and, get her to blurt something out or say something or trap her in a way that would just be terrible for her. So she would be a horrible witness. I agree. Doesn't mean she's guilty, but she would be a horrible witness. Okay. Is Alessi paid per word? Seriously, he ought to be. He's very good at getting what he wants, especially with a judge who doesn't want to give it to him. Josh, thank you for sending something to Mod Chat. I'll take a look at that here. We're approaching 4 o'clock, so it's about time. Just got a phone call from the city. I've got another gig on Monday, and it starts at 6:30. So Monday, as soon as court gets out, I'm going to have to run and set up for that. It'll be good. It'll be good. All right. I think Jenna was a horrible witness. I liked her more than most people did, especially on direct, both the original and second time. On direct, I liked her better than most people did. Cross-examination, she lost a lot of the shine for me. Most defendants are going to be bad witnesses. Are you podcasting tonight or anything else? Barb, not tonight. I've got to call in to Goodman Law's hubby. I've got to get a call in. We're going to talk about some challenge coins, talk about some things that I want to do with those, especially for the channel. Might have to talk to Phil at 2IO Toys. He's already partially designed one as well for me. So some great ideas there. So we're going to look at that. And Jenny, yes, I would say yes on both. I think that's everything. That carries us to the end of the day. There are some great LawTubers, LawTube adjacent channels like my own. commentators out there that are following this case. And I'd encourage you, if you can, to listen to someone who has an opinion that might challenge your own on this one, and to do it and try to see things from their side. I'm not asking you to change your opinion one way or the other. If you're pro prosecution, to switch to be pro Karen Reed. If you're pro Karen Reed, to switch to be prosecution. But I do encourage you to watch and listen and try to see the other angle for a little bit. If nothing else, it might help us understand and shape our own opinions as we do that. I'm pro chaos, says Greeners. There we go. With that, Greeners, there's nothing else to say. All right. Mo says, I've tried. They all seem to quote out-of-court statements, and I can't deal with them. It's really hard to look at this case as this jury is seeing it. Because, as I believe, the jury has no clue what's happened. They have no clue about the first trial. They have no clue. Well, obviously, they know there's some attention. There's some hubbub outside of court. But just, they're keeping their heads down. They're focused on the evidence. And I think they're going to be really surprised when this is all over. Surprised at how much information is out there, both misinformation and otherwise. But hopefully at the end of the day, the juries, when they hear all the information, will feel good about whatever verdict or conclusion they came to, and they feel that justice was done. So tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better. And please stay safe too. Go live again tomorrow, 8:30-ish. We're going to start again. Tomorrow's Thursday, Podcast Thursday. I think we're still on schedule. I'll have to check with Thomas to see if we've got any problems, but I think we're going to do that. So that's all. You guys have a good night. Be good to each other. We'll see you in the morning. Bye-bye.
I was kicked back, taking it easy.
This is not Burger King. People do not get to have it their way.
I don't like podiums, Your Honor.